go ahead and get started.
I'm sorry, can you hold 1 minute? This is Mary. For some reason, I hit something on my other computer and it's talking to me. Just give me 1 second.
Okay, no problem. No problem. Commissioners, are you good to go? And Mr. Molander?
Yes, Madam Chair.
Good here, Madam Chair.
All right, great. Well, good morning, everybody. It is March 25th of 2021, and this is a meeting of the Oil Conservation Division. I'm sorry, the Oil Conservation Commission. It is 9:06, and we will go ahead and get started. First item on the agenda. So I am Adrienne Sandoval. I am chair of the Oil Conservation Commission and head of the Oil Conservation Division. Also with me today are the other two commissioners. Would you each please introduce yourselves for the record, starting with Dr. Engler?
Yeah, this is Tom Engler, and I am the secretary designate for the commission.
All right. Good morning, Madam Chair. Good morning, Commissioner Engler. My name is Greg Bloom. I'm the Assistant Commissioner for Mineral Resources at the State Land Office, and I'm the designate of Commissioner of Public Land, Stephanie Garcia Richard. Thank you.
Thank you. Also with us is Chris Molander, counsel to the commission, and commission clerk, Florine Davidson. First item on the agenda today is approval of the agenda. Commissioners, have you reviewed the agenda? And do you have any changes, or is there a motion to approve the agenda?
Madam Chair, I've read the agenda. I have no changes, and I motion to approve.
And I'll second.
Mr. Molander, would you do a roll call vote, please?
Yes, Madam Chair. Commissioner Engler,
I approve.
Commissioner Bloom,
I approve.
and Madam Chair.
I approve. The motion passes unanimously, and today's agenda has been approved. Just noting that there were a couple of modifications in the final agenda. Agendas items, let's see, 6, 7, and 8 were dismissed and will not be heard today, as is noted. All right, moving on to agenda item number 3, approval of the February 11th and 12th minutes, as well as the February 25th meeting minutes. Commissioners, have you reviewed the minutes, and do you have any changes, or is there a motion to approve the minutes?
Sorry, Dr. Engler, go ahead.
No, go ahead, Greg.
Madam Chair, maybe a question for you or Mr. Molander. I was not at the February 11th nor February 12th deliberation, so I don't know that I could testify to their veracity, but I'm certainly fine voting for the minutes.
Commissioner Bloom, did you review the transcript from the deliberation hearing?
Mr. Moreno, yes, I did review the transcripts from the deliberation hearing.
Based on a review of the minutes from the deliberation hearing, do you have any reason to believe that either the minutes or the transcripts were flawed or erroneous?
Madam Chair, Mr. Bender, no, I believe that the transcripts look good and are not flawed nor erroneous.
So in this situation, you could vote on the adoption of these. It's up to you. If you don't feel comfortable with that, that's also okay. So it's really up to you and your comfort level, but you've done the work necessary to allow you to vote.
Thank you for that clarification, and I will then vote on both of those items.
Well, this is Tom Engler, Madam Chair. I've read all the minutes. I attended all the meetings, and I motion to approve the minutes.
Just for a clarification, Dr. Engler, I'm assuming you mean the minutes for February 11th and 12th and February 25th?
That is correct.
Okay, is there a second?
I so second.
Mr. Melander, would you do a roll call vote, please?
Yes, Madam Chair. Commissioner Engler,
I approve.
Commissioner Bloom,
I approve.
and Madam Chair.
I approve. The motion passes unanimously, and the minutes for February 11th and 12th and the 25th have been approved. Agenda item number 4, to adopt the annual resolution setting forth reasonable notice standards for the commission public meetings. Commissioners, have you reviewed the annual resolution document, and do you have any either edits, or is there a motion to approve?
Madam Chair, yeah, this is Tom Engler. Yeah, I have repeatedly read this document and read the most current one last night, and I have no additional changes to the document, and therefore would like to motion to approve.
Madam Chair, I'll second that.
Mr. Melander, would you do another roll call vote for us, please?
Yes, Madam Chair. Commissioner Engler,
I approve.
Commissioner Bloom,
I approve.
and Madam Chair.
I approve. The motion passes unanimously, and the annual resolution for setting forth the notice standards has been adopted. We will move on to agenda item number 5, which is final action in case number 21528. This is the public rulemaking hearing under 19.15.3 NMAC on the application of the New Mexico Oil Conservation Division to consider proposed rules to regulate the venting and flaring of natural gas from oil and natural gas production and gathering facilities. This has been an extensive process over the past, actually, couple months, really. Starting with a motions hearing back in December, then following with 2 weeks of testimony at the beginning of January, then following with 2 days of deliberation in February, which leads up to today, which is a vote on the final order and rules for Part 7, Part 18, Part 19 as modified, and then new rules, Part 27 and Part 28. Commissioners, have you reviewed the final rules and the proposed final order? And if so, do you have any changes, or does this reflect what the commission stated in deliberations on February 11th and 12th? Dr. Engler, would you like to start?
Certainly can, Madam Chair. I have repeatedly read all of these, including yesterday's last version. I have no more changes or any changes at this time, and motion for approval.
And Madam Chair, if I might, yes, I have read the latest versions from yesterday of the final rules and the final orders. I have no further edits or suggestions there. Additionally, I was able to review the exhibits from the hearings. Commissioner Kessler was bad enough to pass off to me about 3 linear feet of exhibit binders, which which I read and reviewed, as well as the hearing transcripts from the 10 days of the hearing and the 2 days of the deliberations. Also, the dozens, if not 100 or so, public comments that were received and posted to the OCC, OCD website, from people concerned about the environment to communities, leaders really from the Northwest and Southeast, looking for a balanced methane rule, and also from individual members of the oil and gas community, including IPA&M and their comments. Also reviewed multiple drafts of the final order in parts 27 and 28 of the rule. So I would second Commissioner Engler's motion.
Thank you, Commissioner Bloom. I just, before we do a roll call vote, I would like to also state that I have reviewed the final rules multiple times as well, and have no changes at this point. I think they very much reflect what the commission discussed and intended during deliberations, as well as the final order. And I also, that also reflects what the commission discussed and intended during deliberations. Mr. Molander, would you please do a roll call vote?
Yes, I will. And just to be clear, this is for adoption of the order and the rules for the venting and flaring rules and rulemaking. Commissioner Engler.
I approve.
Commissioner Bloom.
I approve.
And Madam Chair.
I approve. The motion passed unanimously, and the rules are adopted. I think this is a huge day for New Mexico. I'm really excited to have been able to be a part of this, and I just also want to thank all of the members of the public who took the time out of their days to comment during the rulemaking proceedings or provide the commission with written comments, as well as all of the parties who were involved, climate advocates on behalf of many of the parties that they represented, the Environmental Defense Fund, the State Land Office, the New Mexico Oil and Gas Association, and last but certainly not least, the Oil Conservation Division and all of the work that they did, along with help from some contractors at Insight Energy. And I, again, really very much want to thank all of those parties, as well as, there are a couple more. I promise I won't turn this into like an Emmy speech here, but as well as all of the time that the commission has dedicated to this, Dr. Engler and Mr. Moander, and then Commissioner Bloom for reading all of those transcripts and documents. It was a Herculean effort, and I am just, again, so proud to be a part of this, and I think it's a really huge day for New Mexico. So, again, thank you to everybody.
And Madam Chair, just for the sake of clarity for the parties, everything will be submitted to proper entities pursuant to the Rules Act. I will see what can be done about getting these published today, because I believe today is the registered deadline. Otherwise, there may be a 2-week delay in that. But in any event, the documents will be sent out today to try to get things moving forward as quickly as possible.
Okay. On the matter of getting the order signed, commissioners, or is there any action we want to take on how to get the order signed?
Well, Madam Chair, this is Tom Engler. Before I say that, in your compliments, you forgot one person, and that was yourself. So, again, all the time and effort of us and you and all your leadership was quite beneficial. So the first thing I want to say is thank you also to yourself. So on the second item about signing, I saw, so I guess I don't, we can sign, what's the problem with us not signing individually, I guess is my question. I saw where we could give you the permission to sign on our behalf, but why can't we just sign it and send it electronically right away? Is there a reason for that? Maybe Mr. Molitor could explain.
Commissioner Engler, I explained that what you can do is you can simplify this by delegating authority to the chair, or alternatively, it can be signed individually. I would suggest that the commission avoid doing like triplicate signature because there's 3 commissioners. But that's going to require everyone to sort of pay attention to their email, hopefully today, to be able to put those signatures in, and you're going to have to circulate the same document. So that my thought would be to simplify. There could be a motion and subsequent vote on delegating authority to the chair to avoid that. But I also understand, given the labor invested by each and every one of the commissioners, I can understand why you might want to sign it and have your name put on the work that you completed. So I leave that to the discretion of the commission. But if the commission chooses to go with the multiple signatures, to make that as tidy and expeditious as possible.
Well, thank you, Mr. Molitor. Yeah, it's not that hard to circulate, sign. You can do it pretty quick, but I guess Commissioner Bloom, what's your opinion on that? What would you like to do? I guess I could go either way, but I was kind of thinking that I would sign it and then just send it right along, but what would you like to do, Commissioner Bloom?
Madam Chair, Commissioner Engler, I would be glad to sign it electronically today if we could get that done.
Yeah, because I could do that today too, quickly.
Okay. It sounds like that may be the preference here. Mr. Moander, I guess maybe the best way is to send it to one person first and have them sign it and then send the copy on to the next person so we can make sure to get it all on one document.
We can do that, and I'm assuming that everyone's signature tools are through Adobe or some sort of PDF reader. Is that a fair assumption?
That is correct. I could do it many different ways.
And Commissioner Bloom?
Yes, through Adobe. Yes.
Okay, I will circulate that as soon as the hearing's over.
Okay. All right, great. All right, well, that moves us into agenda item number 9, which is a motion hearing in de novo case number 21744, an application of Cimarex Energy Company for hearing on case number 21629. Are the parties with us? Let's see, Mr. Padilla and Mr. Savage.
Madam Chair,
I see both of you. Okay. Mr. Padilla, do you want to do a sound check?
I'm sorry.
Oh, okay, I can hear you. Great.
I didn't hear you exactly. What did you request?
I just want to make sure we've got you here and we can hear you.
Okay.
Sounds like we're good. Mr. Savage, I just want to make sure I can hear you.
Yes, Madam Chair. Good morning.
Okay, great. All right. So in this item, the commission has, been provided with the documentation that you guys have sent along. The commission has read that documentation. I would encourage each of you not to rehash that information that has already been provided to the commission, and instead focus on any sort of responses or new information and not rehash what has already been sent. With that, Mr. Padilla, would you like to provide the commission with an update?
Sure. This case is, as I've said in the pleadings that we have filed, is a fairly simple case. I can tell you that I've been around for quite a while, since the division was formed under the Natural Resources, Energy and Natural Resources Department. And a lot of things have changed over the years. What hasn't changed is section 70-2-13 of the New Mexico statutes that requires a party to be a party of record in order to take an appeal to the commission. That's never changed. The practice has been at division hearings, even if somebody does not want to get on the record with the case, is to enter and make an entry of appearance. There is no excuse, and I don't see any way around not becoming a party of record in order to be able to take a case to the commission. Cimarex has filed and admits that it received notice. This is not a notice case whatsoever. Neither is it colorable as a notice case or anything of that nature. The excuse that Cimarex uses is that its employees made mistakes and did not notify the proper people about entering appearance or becoming involved in this case. And Mr. Savage makes a very clever argument about a case being broader than the hearing. Well, it doesn't matter how you address all of these things. If you're not a party of record at the division hearing, you're not in the game. That's just very simple. It's jurisdictional in terms of exhausting administrative remedies. If you didn't get in the game to begin with, you're not entitled to a de novo hearing. For the commission to open this case is to allow all kinds of parties now to come in after the fact and say, well, I'm an aggrieved party, I'm adversely affected. Of course, Cimarex is adversely affected in this case. It was force pulled, but it can participate in drilling of the wells under the compulsory pooling orders that were issued by the division. To say now that they ought to be allowed because it was Christmas time and they changed their procedures and that kind of thing. The division has not changed its rules. I think since the pandemic started, I think there were some continuances of cases, but by and large, the division has continued to operate. We've all learned to deal with virtual hearings and participating through voice or some other way. Last week, I did a full-day trial in Hobbs, sitting here at my desk. My client was in Texas, and so were all the other witnesses on the other side. So so there are no excuses. And I think the issue is here. Cimarex is not probably wants to operate the wells, but it should have got in the game at the very beginning without mistakes on its part. The hearing was held, and now there's contentions that there were misrepresentations and made by the land witness in his affidavit. Well, it's a little too late to argue whether or not there were misrepresentations And I don't see that as rising to some kind of fraudulent activity. A hearing is held and you don't participate, then you're out. You don't become a party of record. 70-2-13 is very clear, and so are all the other appellate issues on section 72-30 or 25 that governs appeals from the commission to the district court and rehearing requirements. We cited a PUBCO case there where someone did not ask for a rehearing, and the court said, no, you didn't exhaust your remedies. So to exhaust the remedies, administrative hearing is necessary, and that means that you have to jump in at the very beginning after you receive notice of the hearing and become a party of record. Now, Cimerex also cites a pretty good case for us, I think. It's energy new energy economy versus public service company and a whole bunch of other people in the rulemaking procedure before the Environmental Improvement Board. The issue was who could be a party to an appeal. We've cited some of the language in there, and and it contemplates that to become a party, you have to be involved in the hearing to begin with. There's some environmental board rules in there that are cited, but the danger in allowing anybody to participate after the fact is anybody then can intervene, having had no participation with in the initial hearing. And so, especially in a rulemaking procedure, in this particular case, the court first had to decide that rulemaking hearings should have the same rules as adjudicatory hearings, where you do have specific notice requirements. And some of these cases, it's just like filing a pre-hearing statement before the division or the commission. You have to state who your witnesses are, but you don't even have to go that far. You just have to enter an appearance and be a party of record in order to, I've done it numerous times for clients who did not participate in hearings but wanted to be involved, and they were interested people, and we filed entry of appearances. All companies that have proceedings before the OCD do that, and they may have an issue down the line as to how their acreage is going to be pooled or not pooled, but they have the advantage of having the opportunity to have a de novo hearing. But Cimerex in this case did nothing. There is no room in the statutes in 70-2-13 for excusable neglect, and that's what we have here. If you miss, you miss, and you can't get out. You can't then come back in and say, okay, I'm aggrieved, therefore I want to hear it. I'm sympathetic, but the fact of the matter is that 70-2-13 does not have room for anyone in the commission or in a de novo proceeding before the commission without having become a party of record at the initial hearing. I think that's all I have in terms of argument. I just think that if the commission were to open this case, then it sets a bad precedent, and it really goes against 70-2-13. So if Cimarex is allowed to have a de novo hearing, then without having been a party, then the commission will allow almost everyone in any other case to do the same thing. So we ask that the de novo application be denied. Thank you.
Thank you, Mr. Padilla. Mr. Savage, would you like to respond to that?
Yes, ma'am. Madam Chair, Commissioners, Mr. Molander, good morning. I'm Darren Savage with Aberdeen and Shields Santa Fe office representing Cimarex Energy Company. I'll try to get straight to the point. So Colgate sounds like, based on that presentation, that Colgate's main argument, really its only argument, is that because Cimarex failed to make an appearance at the division's hearing itself, that its application for a de novo hearing should be barred in absolute terms without further consideration. Cimarex believes that such a policy is too harsh and unwarranted under the facts and circumstances, and is not supported by the meaning and purpose of the Oil and Gas Act. Let's be clear, there is nothing in the Oil and Gas Act, its rules and regulations and related case law that bars Cimarex from being a party of record and qualifying for a de novo hearing. In fact, the contrary is true, that a de novo hearing is fully warranted, justified, and necessary even under the facts and circumstances in order to uphold fairness and substantial justice, as noted by the case law cited in our pleadings. Importantly, to deny Cimarex and other parties in similar circumstances an option or pathway for a de novo hearing, to exclude completely this possibility, is to create the wrong incentive for an applicant. For once the applicant knows that notice has been sent and no party has made an appearance for the hearing, the applicant would then be free from all accountability and would know it has license to make misrepresentations to the division, whether materially false or misleading, in order to secure a pooling order. Such incentive should not be reinforced, Madam Chair. Cimarex submits that the better option would be to provide an incentive to maintain the integrity and legitimacy of the proceedings to the extent available under the law. Therefore, the better option is to allow a party adversely affected to become a party of record, even if the party was not able to attend the hearing, when the legal criteria and circumstances have been met. This option would provide the Commission with an avenue for addressing questions of substantial justice and correcting the proceedings if necessary in order to uphold their legitimacy. And as shown in our proceedings, the Oil and Gas Act and case law fully support this option. 7213, for example, states that a party of record adversely affected has a right to a de novo hearing. And New Mexico case law demonstrates that the Commission and Division have full discretion and full authority to determine who should qualify as a party of record. This is unambiguously clear from both the Vanzi case and Commission Order 14097-A. Cimarex satisfied all the criteria under the rules and regulations and under the Oil and Gas Act to be considered for and to qualify as a party of record adversely affected. To qualify under the Commission Order, for example, a party must participate in the case in a legally significant manner. If I may offer an example of a common scenario that occurs often before the division, that of a party who is able to make an entry of appearance prior to the hearing, often that party will not protest or object and will not participate in the proceedings except for their presence. Such a party will not even ask any questions of the applicant, but will state that it is only appearing to observe and to preserve its appellate rights. Now, this party is guaranteed a right to a de novo hearing, as it should be, even though it could be argued that the party did not participate in the case in any significant manner. Yet such a party, having satisfied the statutory formalities, should be able to exercise this right. Now compare this common scenario to the facts and circumstances of Cimarex's entry of appearance. Cimerex, as explained in the pleadings, was not able to attend the hearing, but nonetheless, it was able to satisfy all the criteria for what constitutes legal participation in a significant manner. And it satisfied the criteria under the rules, regulations, and statutes of what constitutes a party of record. As required by the commission order, Cimerex provided valid reasons for not being able to attend the hearing. Upon realization of its oversight, Cimerex immediately filed an entry of appearance in the case, satisfying the rules and regulations for being a party to the proceedings, and timely filed for de novo hearing pursuant to 7213 and pursuant to Division Order 21575A, which offered Cimerex that it had time to request this option. In doing so, and in accordance with the commission order, Cimerex provided the basis for its opposition to Colgate's application and provided new evidence substantiating its opposition. Furthermore, Cimerex provided new evidence coupled with proper legal arguments for finding that Colgate failed to meet the necessary criteria for obtaining a valid pooling order. And Cimerex accomplished and met these criteria while the case was still open and prior to it being fully closed and finalized. Now, if you look closely at the details of this case, in its pooling checklist, which is required to be completed and submitted to the division, and which was signed by Colgate's counsel, Colgate failed to complete its requirement for the submission of its C-102 documentation. Instead, on the checklist, Colgate explicitly represented to the division that it would submit its C-102 documentation on January 8th, which was the day after the hearing. However, Colgate, despite its representations, failed to do this, thus failing to complete and finalize its application. It did not submit its C-102 documentation to the division until January 27th, more than a week after Cimerex had made its entry of appearance. And Colgate did not finalize its application on its own initiative, but did so in what was clearly a direct response to Cimerex making its appearance. Now, it is readily apparent from the record that Colgate would never have completed its submission of its application had not Cimerex become directly involved as a participant in the case and its proceedings. Clearly, this exemplifies Cimerex's participation in a legally significant manner. In the meantime, Cimerex continued its legally significant participation by filing competing applications that offer alternative development plans for the prevention of waste and the protection of correlative rights, consistent with the mission of the commission and division. Now, 7213 states that it is not only the proceeding that is important in an appeal, but also the matter, which the statute separates from proceeding by the phrase matter or proceeding. Cimerex was not able to attend the hearing, but it has been significantly involved in and has significantly addressed the matter of concern in these proceedings. And it is the matter under the statute, that being the matter of Colgate's intentional misrepresentations and defects in this application, its failure to enter good faith negotiations, and its failure to make attempts to enter a voluntary agreement with Cimerex that constitutes the main issue warranting a de novo hearing. This is the issue that Cimerex has been intricately involved in through its participation in this case. 7213 states specifically that when any matter or proceeding is referred to an examiner and a decision is rendered thereon, a party of record adversely affected shall have the right to have the matter heard de novo. Cimerex referred the matter of Colgate's failings to an examiner, and the examiner in order number 21575A made a decision and stated that a de novo application to the commission for its consideration was an option. Thus, we respectfully request that the commission allow Cimerex to proceed as a party of record adversely affected, which we submit Cimerex has qualified for pursuant to Commission Order 14097A, pursuant to the rules and regulations governing entries of appearances and related case law. Now, in the alternative, Cimerex shows in Section 4 of its response that the de novo hearing should also proceed on the basis of excusable neglect. we've clearly established that the rules of civil procedure apply, and 1060B applies to agency adjudications and should govern these proceedings. Cimarec's mistake, which it acknowledges, squarely falls under the excusable neglect within the case law. Cimarec submits that it should give consideration to a policy. Cimarec submits that the commission should give consideration to a policy and mechanism for the commission to correct wrongs and injustices in the proceedings of these kinds of cases, the kind of case before the commission today, when the facts and circumstances allow and the letter and intent of the Oil and Gas Act can be properly upheld. Cimarec offers two legitimate, legally sound avenues for addressing such concerns in the present case, as well as in future cases of a similar nature, should the commission decide to act upon such options, which it has the authority and discretion to do. Mr. Padilla talks about opening up the floodgates, or the possibility of opening up the floodgates for parties who make appearances after the fact. Now, clearly, this is not the case. There's incentive for a party to make an appearance before the hearing because that guarantees the right to a de novo hearing. And then on the other side, the Commission Order 14097A shows an example of a party who clearly does not meet the qualifications of an entry of appearance and a party of record, even though it made an entry of appearance. We're talking about a third category here that could be easily distinguished based on the criteria listed in the Commission Order 14097A. So in view of the options that are available, Cimarec respectfully requests that the Commission deny Colgate's motion to dismiss and allow Cimarec the opportunity for redress that would be provided by a de novo hearing. Thank you very much, Madam Chair.
Thank you. Before we go back to Mr. Padilla, I just want to open it up for the commissioners. If you have any questions, either from Mr. Padilla's original statements or of Mr. Savage. Dr. Engler, Commissioner Bloom, do you have questions?
Madam Chair, one question for Mr. Savage. Mr. Savage, if we find for you, can anyone or everyone that misses appearance deadlines be able to become a party of record at any time and receive a de novo hearing?
The question is, would anybody who does an entry of appearance after the hearing, would they qualify as a party of record, and would it therefore overly burden the process and proceedings? That's the question, Commissioner?
Yes, okay. That was pretty close. Yeah, thank you.
So I do not believe that would be the case. I think there's two scenarios in the situation. So the first scenario is the party makes an entry of appearance prior to the hearing and attends the hearing. That clearly is they qualify as a party of record. That's very clear. So that's easily determinable. And on the other side, on the other extreme, you have the Commission Order 14097A. And in that, they delineate specific criteria by which you could efficiently determine who would be a party of record. Now, in that particular commission order, Amtech falls way short of those criteria and can immediately be weeded out as not being a party of record, adversely affected. And we believe that would be the case for any party that just decides to make an entry of appearance without justification could easily be discarded and weeded out by the commission in an efficient manner. So I don't believe it would overburden the process. Then there's this third category, and we believe that this is where Cimarec falls into, and that's when like significant issues come into play, such as the legitimacy of the proceeding, the integrity of the proceeding, and whether or not the claims of the applicant should be addressed. And then there's the list of criteria, whether or not the party that made the entry of appearance, whether or not they provided new evidence, whether or not they timely made application for de novo hearing, and whether or not they timely made a entry of appearance, whether or not, in our case, the case looks like it was still active and still open because Colgate had not finalized the submission of its application. And we believe that the order was issued, the division order was issued prematurely. So anyway, to answer your question directly, we do not believe this would overburden the process.
Thank you, Mr. Savage.
Thank you.
Dr. Engler, do you have any questions?
I have no questions. Thank you.
I don't either. Mr. Padilla, do you have any reply to Mr.
Yes.
Savage's statements?
Yes, I do. Thank you.
Please proceed.
Mr. Savage argues that Colgate would have no accountability. Of course, it would have accountability. It has accountability on the compulsory pooling order. It's got to follow the terms of the compulsory pooling order. It's no different than if there were a joint operating agreement, except here you have a regulatory order that requires some protocol for drilling the wells and requiring and inviting joinder in the well under the compulsory pooling order. So the question of accountability is not even, is very remote. I've brought cases under compulsory pooling orders to seek compliance of an operator through the division. Now, in terms of, I like Mr. Savage's argument, and I think it's funny. He mentioned several times that Cimarex was not able to attend a hearing. Well, that is total. A company like Cimarex that is not able to attend a hearing virtually or otherwise, it begs a question here. When they have, it's apparent from their pleadings that they have a system for tracking compulsory pooling cases and to take care of that. In this case, they didn't do any of that. It's not even a remote thing to say they weren't able to attend the hearing. My God. Now, they made their entry of appearance on the same day that the order was issued, on January 9th of this year. That's pretty late. And now they say they have new evidence and they filed competing applications now before the division. Those competing applications should have been filed after they got the well proposals from Colgate. They didn't do anything. They just sat on it. Maybe they blame COVID or something, but no one else is blaming COVID in my sphere of well conservation hearings. A matter of fact, companies like Colgate have people reviewing dockets. I get calls from clients before they receive notice of a hearing, because they're tracking dockets of the Oil Conservation Division, and they track whether any of their oil and gas leases are being affected by the thing. I think it just begs the question to say that you can come in at any time. I think Commissioner Bloom's question is very appropriate, is that I would certainly take advantage of it if I had a client who missed entering an appearance and becoming the party of record at a division hearing. Then you can make up anything afterwards and say, well, I'm an adversely affected party. Of course you are. You received notice because you're a working interest owner. And if you don't do anything and don't enter an appearance and preserve your appellate rights, you don't have the right to have a hearing before the commission. Thank you.
Thank you, Mr. Padilla. Commissioners, do you have any other questions?
Hey, this is Chris Mohan. Sorry, I had my internet crap out. I just have one question, and it's for Mr. Savage, because I'm trying to get my head around the issue of the excusable neglect concept that's being argued here. And I'm basing this kind of like Mr. Padilla on my background as a litigator. Usually excusable neglect that I've encountered, and that is, this is anecdotal, I recognize that, tends to center around blown deadlines, where just deadlines were overlooked by counsel in most cases. In this case, it seems that it's attributable to the party. What I'm seeing here is similar to, and I'll get to this question, but I kind of need to lay this predicate. This is similar to how the Metro court system works, or magistrate court system, in a sense that sometimes the division level or the magistrate level, those hearings sort of become meaningless because of the de novo appeal right. But in this case, what I'm seeing is excusable neglect could be argued to permit what I would see as sort of a prejudice to the parties to appear at the hearing, because a moving party such as Cimerex is allowed to collect all the information from the underlying hearing. And even though the Cimerex would presumably provide for its technical filings and so on at the commission level, it ends up prejudicing everybody who didn't participate, who had arguably a legitimate interest in the underlying subject matter of the original division hearing. So I'm trying to reconcile this, because it's sort of like the excusable neglect is we didn't show up for trial. And that does seem to me pretty extreme. So I'd like to hear a little more on Cimerex's position about that.
Yes, Mr. Molander, thank you for that question. First of all, the excusable neglect argument, it is an argument in the alternative. We believe that the main thrust of the law and the statutes support the party of record argument. So, but in the alternative, so it is a high standard, and it's up to the discretion of the commission to determine whether or not it's excusable in that sense, whether or not it meets that standard of negligence, and whether it be appropriate. And I believe they would take into the equation the question of the prejudice to the parties. So it's an evaluation based on the totality of the facts and meeting the standard of excusable neglect. Now, if you look at our case law that we cite, both New Mexico case and the related 10th Circuit cases, the scenarios that are provided account for mistakes made by the moving party. For example, Cimerex, and like in the instance that we looked at, it was a paralegal who made a direct mistake on a calendar and not and missing a deadline. as a result. In our situation, Cimerex, it was like a perfect storm that came together to cause the sequence of events, and the main one being that the land tech who was triaging the notices mislabeled the subject heading on the email and said it applied to a saltwater disposal well instead of a pooling unit for an oil and gas well. And therefore, even though you can argue that they should have been on top of it, it's understandable. It falls into the realm of being understandable that a landman who's very busy, who gets thousands of emails on a regular basis, and trying to go through and decipher which ones are important, they happen to overlook that one because of the mislabeling. So, the question of prejudice, yes. I don't think anytime you raise the flag of excusable neglect, that's going to be an automatic ticket. But I think, upon a proper evaluation, it could come into play.
And thank you, Mr. Savage. The reason I asked that question about knowing that it's in the alternative is because statutory arguments are pretty dry and technical, whereas arguing something like excusable neglect tends to have more nuance. And I appreciate that answer. So thank you.
All right, thank you.
I just have one, I think, quick question. Mr. Savage, did Cimerex enter an appearance at least one business day prior to the pre-hearing statement filing date?
Yeah, that is correct. We entered the appearance that morning of January 19th. At that time, reviewing the website, there was no issuance of a division order, and it was filed the next day of record. So we weren't aware of that the order had been issued yet, and we filed according to the time available to us in that regard.
Prior to the order or prior to the pre-hearing statement?
Oh, I'm sorry. We filed prior to the order, the issuance of the order. We didn't, the pre-hearing statement, are you, Madam Chair, are you referring to the pre-hearing statement that would have been filed prior to the hearing? Obviously, pre-hearing statement.
Yeah, so 1915-410C requires that a party who has not, it says a party who has not entered an appearance at least one business day prior to the pre-hearing statement filing date provided in paragraph 1 of subsection B of 1915-413 NMAC shall not be allowed to present technical evidence at the hearing unless the commission chairman or division examiner for good cause otherwise directs.
Right, that precludes them from entering technical evidence at the hearing, but I do not believe it precludes them from being a party of record or making an appearance in the case.
Okay.
The new evidence that we provided after we did the entry of appearance, we did a entry of appearance. The new evidence we provided would be in conformity and in accordance with the Commission Order 14097A, which the Commission reviewed a party after the hearing doing an entry appearance and whether or not they entered new evidence to justify that untimely entry of appearance.
So maybe the next question is, how do you expect to really have any sort of meaningful impact on this if you don't present technical evidence?
We believe that the evaluation provided by the Commission in 14097 is really the criteria that should be looked at. We believe we became a party of record adversely affected based on our filing while the case was still open and prior to all the completed submissions, including the filing of the division order, which occurred the day after our entry of appearance. At that point, then the question becomes, do we qualify under as a party of record? And the case law and the statutes are clear. The commission has full authority to make that determination, even at that point of the filing. The new evidence it's not a question of new evidence being presented at the hearing. It would be a question of whether or not there is new evidence provided at that point of the filing of the entry of appearance after the hearing that could justify, under the Commission Order 14097A, that could justify whether or not Cimerex meets the threshold to be a party of record under those criteria. And they're very clear in how they delineate those criteria in that Commission Order.
Okay, thank you.
Thank you.
Commissioners, do you have any other questions for the parties?
Madam Chair, I do not.
Madam Chair, I do not as well.
Mr. Moander, any other questions from you?
No, Madam Chair, thank you.
Okay. All right, well, I think at this point, we have a couple options, commissioners. One, I'm willing to listen to any sort of path forward that either of you have. The other option is that we could hold this in abeyance and either one, ask Mr. Moander to maybe do some additional legal research, or two, ask the parties to do some sort of post-hearing brief on this for additional information. I do think that this is a pretty important decision, and I do think that there very well could be implications moving forward based on what the decision is here. So, I want to make sure that we're making the right decision here. And if that takes more time, that's something I'm comfortable with. But I'll, I guess, open it up to either of you and see if you have any thoughts on.
Madam Chair, do we go into executive session to discuss this, or are we going to do this in the open public forum?
Mr. Moander, do you have any?
So what's going on here is this isn't really adjudication in terms of the substance. So with a motion like this, actually, I'll be honest, I didn't examine that bill here. If you could give me just a minute, let me take a look at something and double check that primarily. And it just something I do want to ask before I do that, though, is there any, can either of the parties tell me whether there's current or like very pending, I guess we'll call it pending activity involving the underlying order at this point? Like, is any action being taken about any of the well or the pooling or wells, anything like that right now? Can anyone tell me that?
I can tell you that Colgate is proceeding as though they have a valid order, and I believe that they have sent out a request to submit money. So there's obviously, I don't know how far they'll go with that, but without a clear decision by the commission. But I may add something that I probably should have added earlier, is that in a question that you had, Mr. Moander, is that it's pretty much like a statute of limitations. You can't waive the statute of limitations if you don't become, in this case, a party of record. If you blow a statute of limitations, you're out. You're precluded. and this is no different. But I think Colgate is proceeding with under the order.
Okay, and I appreciate that, Mr. Padilla. Mr. Savage?
Yeah, Mr. Belanger, thank you. Cimerex did receive that election letter that Mr. Padilla pointed out. We plan as a result, and since it sounds like that there might be a possibility for more time to address this important issue, we were planning on doing a motion to stay the order under 1915-423B. And also we were looking at, and we don't believe, Mr. Padilla might be able to confirm this, but we don't believe that that Colgate has applied for permits. There's a federal permit involved in this. And I understand that there's a moratorium on federal permits. So I don't believe that Colgate would be prejudiced if we spend a little time looking into this to make sure that the right decision is made.
Okay, that's helpful, and you're right. I don't look at plats and stuff necessarily, so thank you for sharing about the federal land issue. As to
just a correction, there's not a moratorium on permits.
Has it expired? Did that 60 days?
It expired. Well, there was never a moratorium on permits. There was a requirement that instead of being approved at the field office level, they had to go up to headquarters for approval. That sunset on Sunday, I believe, and there's now a new memo and guidance that's out there, but there has never been a moratorium on permitting.
Okay, thank you for the clarification and correction on that. We still do not believe that Colgate has applied for the permit, so that's a lengthy process. We also have Cimerex does have competing applications in play, and we believe those competing applications would do a better job to prevent waste and protect correlative rights. And so that's another consideration to take into account, we believe.
So, Commissioners, to follow up on Commissioner Engler's question, I'm taking a look at the Open Meetings Act 10-15-1 sub H sub 2, or I'm sorry, sub 3, and that concerns deliberations in connection with administrative adjudicatory proceedings. So in this instance, I'm just going to read this into the record, and we'll talk about it briefly if we need to. For the purpose of this paragraph, administrative adjudicatory proceeding is a proceeding brought.
Mr. Moander, I'm sorry. When you read, you have to read slower, not faster.
I'm sorry. So for purposes of this paragraph, and that's sub H sub 3, administrative adjudicatory proceeding means a proceeding brought by or against a person before a public body in which individual legal rights, duties, and privileges are required by law to be determined by the public body after an opportunity for a trial type hearing. Except as otherwise provided in this section, the actual administrative adjudicatory proceeding at which evidence is offered or rebutted and final action taken as a result of the proceeding shall occur in an open meeting. So the way I'm reading this is we're not having an adjudicatory proceeding. At this point, the parties have not, while there's a request for a de novo application, this motion is sort of a gatekeeping motion designed to get to that actual proceeding. So I do not think that there's actual deliberations for a motion. There can be discussion by the commission about the contents of the motion, but it would have to be done publicly. So I do not believe executive session is permissible in regards to a motion.
Thank you. This is Tom Engler. Thank you, Mr. Moander. So, Madam Chair, what was, again, go through the list of what's our possible discussion items or solutions?
So I think there are a couple options that we potentially have here. One, if we feel strongly one way or another, and don't need any additional information, then we could make a decision today. Alternatively, if we do not, we could either direct Mr. Moander to do potentially some additional legal research, or direct the parties to do a post-hearing brief to provide us with additional information. I think those are the sort of three paths that we have at this point. But I do have concerns about the precedent of this.
Well,
Something I would point out for the commission here is a couple of points. First is that the commission has just completed a major rulemaking undertaking. And I think that given the nature of the issue, which is pretty serious, it's a standing issue in essence, those are very important in case law at the state and federal level. If the commission would like more time, I think based on the factual circumstances that the parties are facing, there's no crushing pressure. I can say I would not complain about having some additional time to evaluate authorities and so on in order to advise the commission. And as much as I know lawyers, as being one, can go on and on and on, I think both parties here, if they were to submit a final briefing, I would recommend it be done on the same day, so it's not going to turn into a cycle of devolving filings. And if the commission has specific issues they would like to have addressed, to direct the parties accordingly, and then this could be placed on I believe it's the 15th of April, and that's 3 weeks away, so the delay is shorter than usual if matters are vacated to an upcoming hearing. So just some stuff to inform the commission.
well, Madam Chair, this is Tom. Where I guess I have no problem making any attorney work more. Usually I can't understand what they say anyway. I'm not convinced more evidence or more case law will really help me. I'm thinking it might be more prudent for both sides if we had a decision and then they could move forward from there. That's kind of what they're asking for, is whether we should hear this de novo. I just don't see, I guess, and I need more discussion on this from the commissioners. I don't see where, I do agree this has got some very significant implications. I just don't know what I would learn more to make a different decision. That's my first thought.
Okay. Commissioner Bloom?
Yes, Madam Chair, Commissioner Engler, thank you. Commissioner Engler, like you, I don't know that I need to see post-hearing briefs, but I think we could let them happen. I am interested in seeing what Mr. Moander could turn up in terms of looking at the different authorities that he mentioned. And while I'd like to potentially vote on this today, I agree with our chairwoman that there could be some important matters of precedence in front of us. And so I would, I guess, suggest that we take some time, we bring this up at our next meeting, and during that time, both parties would submit post-hearing briefs, and Mr. Moander could use that time additionally to advise us about the outcome of his research.
I mean, I'm sort of leaning in that direction too. I think I would like a little bit more information on sort of the legal side of this and what those implications might be. Well, I understand the parties want a decision, and I also think it can be a pretty critical decision that we're making, and I want to understand all of the legal implications on either end of it. So I would probably lean towards addressing this on the April 15th docket. I think it's the 15th. Yeah, April 15th.
Well, that's fine by me.
Okay. Mr. Morander, I'm assuming we need some sort of motion.
Yes, I think, well, before we move to motion, so it sounds like there'll be a motion on the date when this matter will be heard with finality, which will be April 15th. And I think that we probably want to address directives to the parties, like in terms of both targeted issues and then a deadline for filing. And like I said, in this instance, I'd recommend the filings be contemporaneous. So we're not dealing with a cycle of making a further mess of this. And I do think I do want to make a point here. I think that the commission is taking this issue sufficiently serious because standing is important, and the intent here is not to delay for the sake of kicking the can, but to make sure the commission is as well apprised as possible. So this is in the interest of trying to help the parties. But yes, going back to I think giving some guidance to the parties with deadlines and topics would be appropriate here too.
Okay. What you had said you wanted the briefings today? Is that what I heard originally, Mr. Melander? That seems a little quick.
No. Contemporaneous. In other words, both parties have to do a filing on the same day.
All right. So what are we? Today's just looking at the calendar. Well, there's 3 weeks before our next hearing. I would like things at least a week ahead, if not a little bit more.
I think that because the parties are conversant, obviously about the underlying facts and law, I think that 10 days from today, and maybe even a page limit as well, because I want to make sure that they're nailing down the critical thing. I mean, I think we have a sense of what the parties are focused on, but a page limit, 10 pages, and due by close of business on what, April 5th?
Yeah, probably the 5th. That would be, I think, 11 days.
So I think that's fair, and it also doesn't put a crushing burden on council.
Now, if I may ask, Attorney Padilla, if I may ask, are you going to suggest topics, or how are we going to do this? Or do we just
for the post-hearing response? I mean, what I want to understand is sort of the legal aspects of this, and the implications, the case law, those pieces is what I would like us to focus on.
If I might suggest that, because of Mr. Padilla's question, I think the focus would be, I'd like to see what authority the parties can develop revolving or surrounding particularly OCD and OCC rules and regs if we can, because I think that's going to be critical here, because it's going to be topic appropriate. So we can take the statutes down through the rules, but specifically the rules being OCD, OCC rules and regs. That's what I would like to see from my perspective. I think the excusable neglect issue has been explained, unless the commission feels there's more needed on that. And I do recognize here that getting case law that narrow can sometimes prove difficult in New Mexico. I'm going to be working on that as well, but I'd like to see that fleshed out for the benefit of the commission. And then I'd like to hear the commission's thoughts on that.
That would be useful to me.
Yes, Madam Chair, I would find that useful as well. Mr. Miranda, thank you.
Does that answer your question, Mr. Padilla, or are there any other questions on sort of what the commission?
No, I think I understand the focus that you're looking for.
And if there are questions after all this, I think the parties are now where they can reach out to me to, if there's some clarification or they need some guidance on that, I'm happy to assist.
Thank you.
Okay. Is there a motion from the commission?
I will leave Greg to make the motion.
I'm not sure what this motion would look like, but Mr. Miranda, a suggestion perhaps?
Yes, this motion will schedule the final hearing in this matter on April 15th, the next regular OCC meeting. The parties are directed to file post-hearing pleadings by close of business on April 5th. And the topics to be addressed are additional legal authority, supporting the parties' positions with a focus on OCD, OCC regulations, and that would be including the Oil and Gas Act as well. So I think that should be the motion.
All right, let me try that. All right, so I move this to the April 15th meeting, and the parties shall submit by April 5th, 10-page statements on legal authorities around these issues from precedents around from OCC and OCD and the Oil and Gas Act.
Is there a second?
I'll second.
Mr. Moinder, would you do a roll call vote, please?
Certainly, Madam Chair. Commissioner Engler.
I'll approve it.
Commissioner Bloom.
I approve.
And Madam Chair.
I approve. Passes unanimously. We will wait with bated breath here to see that on the 5th. And we will see you both again on April 15th.
Thank you.
All right, now let's move on to agenda item number 10, pending litigation. Mr. Moinder, is there any update for the commission on pending litigation?
There is, Madam Chair. So at the last meeting, I had vague notes. So on one of these cases, so I wanted to clarify. There was a Rule 74 District Court appeal from Novo Oil. That matter was dismissed with prejudice by Novo Oil on January 21st of this year. So that case is over. The Marker appeal that's sitting in front of the Court of Appeals, which is the only appellate matter that I'm handling right now. Mr. Marker filed his docketing statement as required on March 19th of this year. We are waiting to see what the Court of Appeals does. They may reject the case. They may docket the case. If they docket the case, they may request that I file a responsive pleading to the docketing statement of Mr. Markers. So right now we're in a holding pattern. And then the jalapeno appeal, the New Mexico Supreme Court denied certiorari for that case. I believe it was Wednesday. It might have been, yeah, I think it was yesterday or Tuesday. And so that matter is now over. So the only case that I would expect to be dealing with for the foreseeable future is the marker appeal.
So Mr. Moander, the Novo case you said was what, with dismissed with prejudice?
Yes. So that case is now over completely.
That's what that with prejudice means?
Yeah, with prejudice means that there's no longer an ability to refile or file any additional matters about the critical focus of the case. So there shouldn't be anything else happening.
All right, thank you.
Thank you. Agenda item number 11. Any other business in front of the commission?
Madam Chair, this is not technically business, but I wanted to share my thanks as well to everyone involved in the rule, the venting and flaring rule. I recognize just how much blood, sweat, and tears goes into that sort of thing. And I want to applaud the commission for working with me. And I'm frankly proud of the output. And I just wanted that to be known publicly, that's it meant a lot to me to see the effort, and I respect that. So thank you, commission and parties.
Thank you, Mr. Moander. Yes, it was I think a Herculean effort for all involved.
Madam Chair?
Oh, yes.
I just had one question, and that is, where are we at, or when do we come back to the spill rule scheduling, I guess?
That is on the April 15th agenda.
Okay.
So we will
Just
hear that. Oh, go ahead.
Just for edification, that matter, I'll check the register and verify. I believe notice should have been published, or at least notice will go out through, yeah, like the next day or so, whenever the current publication is due. And then from that point, rulemaking will begin starting on the 15th, or at least the procedure will be initiated.
So we'll have several items on the 15th docket. All right, with that, last item is just a reminder that our next public meeting is on April 15th at 9 a.m. And with that, we will adjourn at 10:32. Thank you, everybody. Have a good day.
Thank you all. Bye.
Thank you all.